Good afternoon, everyone. Welcome to another question and answer session live. My name is Samara Belitzky. I'm an employment lawyer at Samfiru, Tumarkin. I'm located in Ottawa, but I can assist clients all over Ontario and BC. And I'll be here for the next half an hour or so to answer all of your questions related to employment law. So whether it's issues in the workplace, terminations, changes to terms and conditions of employment, questions about severance, questions about medical leaves or medical conditions, layoffs, whatever the topic, I'm here to answer your questions. So please send me your questions, and I'm more than happy to answer as many as I possibly can throughout the next 30 minutes or so. I do, as always, have a few topics that I wanted to mention or address during this discussion, but I'd much rather answer your questions. So send them in, and I will answer them as they come in. To start us off, I will talk about layoffs, which I often do at the beginning of these sessions because it seems like every week there are new announcements of mass terminations or layoffs throughout various provinces. And so we get a lot of questions about that, both from employers and employees. There's a lot of misconceptions surrounding layoffs, both temporary layoffs and then permanent layoffs or mass terminations. And so I wanted to start by giving some general information about what we refer to as a mass layoff or a mass termination. And so what's really important to know when we're dealing with mass terminations or mass layoffs, the reason that they are distinct or a bit different than kind of a regular termination is because when we're dealing with a termination that's considered a mass layoff or a mass termination, it means that many people are being let go at the same time. And because of that, the employer actually has an obligation under the province's Employment Standards Act, the employment standards legislation that provides for the bare minimum rights and obligations for employees and employers, provides that there is a bare minimum essentially that must be provided to employees, which is increased when there's a mass termination. So rather than somebody being owed, for example, a minimum of 4 weeks, let's say, under the Employment Standards Act, their starting off point for severance might normally be 4 weeks. When it's a mass termination and let's say the company has let go of, let's say, 150 people, that employee, rather than a bare minimum of 4 weeks, will be owed a bare minimum of 8 weeks in Ontario. Now, that's just one example, but generally speaking, when we're dealing with a mass termination, that's the big difference when it comes to severance or termination entitlements. It's that the employee will be owed as a bare minimum, the bare minimum starting off point under the employment standards legislation will be higher than if they weren't part of the mass termination or mass layoff. That's the main difference. Aside from that, everything else would essentially be the same as if only one employee was let go, or maybe 5 or maybe 10. But essentially, you would be looking at your severance entitlements for your full severance would not be impacted. It's really just the bare minimum starting off point that gets impacted. If you're an employee, in most cases, you still will be owed your full severance, and that won't be impacted. The amount that you would be owed would not be impacted by whether you were let go as part of a mass termination or on your own or part of a restructuring that maybe only saw 10 employees be let go, for example. So it will not impact your full severance entitlements. The main impact is on your minimum severance entitlements under the employment standards legislation in your province. And that's why it's important whenever dealing with a mass termination, if you are an employee that's being let go as part of that, it's really important to get your package reviewed by an employment lawyer, whether you're part of a mass layoff or not. Either way, it's important to get your package reviewed by an employment lawyer to make sure that you're receiving what you should. But especially in terms of a mass layoff or a mass termination, sometimes employers, are not on top of what they have to provide. And sometimes employers think because they're dealing with financial difficulties, which led to the mass layoff, that they don't have to provide their employees with their full severance or that they can pay them less. There's a lot of misconceptions surrounding mass terminations and mass layoffs for both employees and employers. And so that's why it's really important, if you're being let go, make sure you get your package reviewed by an employment lawyer. Don't sign anything. If you do sign something, you will likely be stuck with whatever it is that you signed. Even if, let's say, an employer is pressuring you, they give you a day to sign, they give you 3 days to sign. Don't let that pressure you into signing. Make sure that you get the proper legal advice that you need to make an informed decision about what you should do and what your options are before accepting anything, before signing anything. So I have questions starting to come in here, so I'll get to the questions. Tamara on Facebook says, I've been working at the same place for approximately 20 years. The owner has sold the business. The new owners take possession next month. They also want all employees to work for the new owners. My question is, am I entitled to receive severance pay? The answer will depend on the context. So when we're dealing with a sale of the business, if the entire company has been sold, so you're currently working for a company and the seller has sold the entire company to the buyer, it's what we call a share purchase agreement. If the entire company has been sold to the buyer, then everybody's employment will continue automatically. You don't need to sign anything. There's no discussions that need to be had. Everything will continue business as usual. All of the employees will automatically continue. The only difference is that the ownership has changed, but your employment is still the same. And on that point, that means that the new employer or the new business owner coming in doesn't have the right to make significant changes to the terms and conditions of your employment without your consent. Everything should basically stay the same. There is a small margin of discretion where the employer might be able to make some changes, small changes, but anything significant to the fundamental terms of your employment requires consent from the employee. And so that's in the event of a share purchase where the entire company is being bought out. The only change is the change of ownership. The owner of the company may change, but everything else stays the same. Your employment would automatically continue. And so no, you would not be owed severance unless they decide to let you go. And it's possible that as part of this deal, the current owner of the company may be responsible for letting go some employees that the new owner doesn't necessarily want to continue to employ. In that scenario, they may let you go, and yes, you'd be owed severance, absolutely. Similarly, if you continue on working and once the change happens and the new owner takes over, they may decide to let you go. They can do that, but they do have to provide you with a full severance package based on your full length of service, your entire length of service with the company. So your length of service doesn't start over just because a new owner comes in. That's with respect to if the whole company is being bought out. If it's a different type of transaction and it's actually only some of the assets of the company that are being sold, for example, equipment or customer list, depending on the type of business it is, if it's an asset sale and the buyer is only purchasing certain assets, that usually does not include the employees. And so in that scenario, in that type of situation, your employment may come to an end if you're not offered new employment with the new owner, essentially. And in that scenario, the current owner, the current employer, may provide you with severance if you're not being offered new employment. If you're not going to be offered employment with a new owner, the buyer in the asset sale, then the current owner would be terminating your employment and providing you with a severance package, or should be doing that. Otherwise, you may be offered new employment with the buyer in an asset sale that's taken over some of the aspects of the company, and they may offer employment to some of the employees or all of the employees. And in that scenario, you would continue on. So it really does depend on the type of sale of the business that's taking place. I hope I've given you kind of comprehensive information here, Tamara, that can apply to either situation. But if you're not sure, if you said it's in the next month or so, when things start to happen, if you're not sure what your rights are and what your employer has to do, definitely get back in touch with us. But yes, in terms of an asset sale, if it's not a situation where the whole company is being bought out, and the employees are not part of the sale, then your employment in theory, would come to an end and you'd be owed severance unless you're offered new employment with the buyer that's taking over. And even then, in certain situations, you still would be owed severance. So it's very important to get advice from an employment lawyer, depending on what the context is here and what ends up happening. I have a question from Vera on YouTube, who says she just turned 65. Can I be forced to retire? The answer is absolutely not. There is a very common misconception that once somebody attains the age of 65, that they have to retire. That is incorrect. There is no mandatory age of retirement for most jobs. And when I say most jobs, I mean, for example, if you're a judge in Ontario, there is a mandatory retirement age. But aside from those types of positions, generally speaking, there is no mandatory retirement age. So it used to be that lots of people retired at 65 because that's when they could access their CPP, their pension plan. But there is no mandatory obligation. You don't have to retire at 65. You can work until any age you'd like. Companies or employers cannot force employees out because of their age, and that's against the law. So not only can they not do it, but it's discriminatory. So employers are not permitted by law to basically try and force somebody out or actually terminate their employment because of their age. And I have dealt with these cases before where someone has come to me at 65 years old and they've been let go by the company specifically because they're 65. And the company has referenced in the termination letter, you're at retirement age, you're 65, so we're letting you go and, we wish you all the best. Companies cannot do that. That's very, very problematic. It's discriminatory. It's a breach of the Human Rights Code. Employers cannot let someone go because of their age, among other things as well, like disability or sexual orientation, just to name a couple. But age is one of those grounds that's protected by human rights legislation. And so, no, you can't be forced out. You can't be forced to retire. The employer should not be terminating because of your age. Again, that's discriminatory and it's illegal. And so if you're in that situation, Vera, definitely contact us. We can assist you with that. And I should also add that a lot of employers, with employees alike, are ignorant when it comes to this. And that's why I say there's just so many misconceptions about age. I've heard from lots of people over the years who really do think that at 65, an employer has the right to terminate or that you have to retire. No, that's not the case at all. And so make sure that your rights are being protected. If you or someone is in a situation like that, just get in touch with us, Vera, and we would be pleased to help you. I have a question from Candace on YouTube who says, my contract stipulates a 2-week holiday. I requested my leave and it was initially approved. Now the owner has backtracked and informed me that as they're understaffed, my holiday will have to be cut short. Can they do this? So when it comes to vacation, employers have the discretion to approve or not approve a vacation request. Most of the time when employees are putting in vacation requests, it's not a problem. Employers approve it without issue, but they do have the discretion not to approve it, to refuse it. Employers also have the discretion to choose when you take your vacation. And so throughout the year, most employers will allow their employees to take vacation as long as it doesn't coincide with an issue with the business. Most of the time, employees can take their vacation essentially whenever they'd like. But employers can specify that you have to take your vacation within certain months or a certain season or a certain time of year. And so when it comes to this specific situation where they approved your 2-week holiday and now they're saying that you have to have it cut short, in theory, they are allowed to do that. They are allowed to say when you can or can't take vacation or how much vacation you can take at a time. That is within the discretion of the employer. In this specific scenario, if let's say you've already booked something and the employer let you know at the last minute that they're going to need you to work certain days and it's not enough advance notice, and maybe you're going to have to pay cancellation fees for accommodations that you've booked, that's a little bit different in terms of who may be responsible for paying for those expenses. Because in this scenario, your employer already approved it. And so, there certainly is an argument that you shouldn't be responsible for paying for any expenses that their reversal causes you. And so in that situation, I would be looking to the employer to be paying for those fees that you had to incur for that last minute change. If they've given you lots of advance notice of the change and you haven't incurred any expenses because of the change, then there wouldn't be anything that the employer would have to provide to you in terms of compensation. And if you're owed 2 weeks of vacation per year, certainly you're entitled to take it, but the employer can decide when that is. And so if they're cutting your holiday or your vacation short, I don't know by how much they're cutting it short, but if, let's say, they're cutting it short by a few days, certainly you're still owed those few days and you would be permitted to take them at another time. But again, it has to be approved by the employer. I have a question from Tim on Facebook who says, I worked in a call center for about 10 months. The company decided to let everyone go and move operations to the Philippines. 185 people were let go. I was not offered anything at all. Should they have offered severance in this situation? The short answer is yes. You were employed. It was short service. It was 10 months, but you were still employed by a company for 10 months as an employee, and they terminated your employment. Regardless of the reason, they can shut down the company, they can move it to the Philippines, they can not move it there, they can do, whatever they can within the confines of the law. But if they're letting you go, they have to provide you with notice or severance. And so you've said, Tim, that you haven't received severance. So my question too would be whether you received notice, because a lot of people don't realize this, but the default when we're letting somebody go is actually notice. So the employer can actually provide you with working notice of your termination rather than paying you out severance or termination pay. So they can either give you notice of your termination and say, for example, your employment's going to come to an end in 8 weeks. So you'll work the next 8 weeks, and then that will be your last day after that. Or they can say, today's your last day. Here's 8 weeks of pay in lieu of notice, which we often refer to as termination pay or severance pay. Now, I'm just using 8 weeks as an example here. The amount, of course, will depend on, things like your age and your length of service, among other factors. So every case is different. But employers do have the discretion to choose how they provide it, whether it be working notice, pay in lieu of notice, or sometimes a combination of the two. And so if you received notice that they were going to be shutting down the company, and you received a notice in writing saying, as of this date, this is your termination date, and you received notice of it, that may satisfy your severance entitlements, because it does work in the same way. In the eyes of the law, working notice and severance pay are the same thing. And so that working notice does kind of give your employer credit, if you will, towards your severance entitlements. I see that you sent more information here, Tim. They announced 3 months before the layoff. I continued working there until the last day. Okay, so if you received a letter that specifically provided you with your termination date, and they did provide you with 3 months of working notice, given that you had 10 months of service, that would be a reasonable amount of notice of severance for someone in your situation. Again, I don't have your age, I don't have your position or your compensation. These are all factors that we look at when we're assessing severance, but just given your length of service of 10 months being quite short, the fact that you did receive 3 months of working notice of your termination would be in the range of what your severance would be. And so there wouldn't likely be anything further that would be owed in that situation. But if there's other information that I'm missing, if, for example, you have a medical condition that prevents you from working, that could change things as well. That could mean that you're owed more severance. So there's all different factors that are at play. But if it's a straightforward situation, and you received 3 months of working notice, that is is that the employer essentially providing you with 3 months of severance, even though you had to work for it. But in the eyes of the law, it's the same thing. And so with respect to 10 months of service, the bare minimum would have been 1 week of notice. That's the bare minimum that you would have been required to receive. And then in terms of your full severance, it would be a range, but you would be right in that range. Could be 2 months, could be 3 months. That would be kind of the range for you with 10 months of service. Again, depending on your position, your age, that range could change. It could go up and down a little bit. But just based on 10 months of service alone, without having any other information, that is the range that you would fall into. And so there wouldn't necessarily be anything further to pursue here. But certainly if you want to review your situation in detail, Tim, and get a more comprehensive legal opinion on it, just get in touch with us. We can go through all the details with you and provide you with a more definitive legal opinion on your entitlements. All right. I have another question here from Joanne on YouTube. Joanne says, I was recently terminated. I received 2 months notice and 12 months of severance. So this is exactly what I was just talking about. This is a situation where an employer provided a combination of the 2 months working notice plus 12 months of pay in lieu of notice or severance pay. Is the length of the notice period versus severance period negotiable? I would like to increase the notice period to at least 6 months so I can continue my job search. Okay, so when you talk about notice period versus severance period, what I think what you're talking about, Joanne, here is the working notice versus the pay that you're receiving. Because altogether, when we're looking at this from an employment law perspective, we actually refer to the notice period as being the full amount you're receiving. So it would be the 2 months of notice plus the 12 months of severance, so that altogether your employer is offering you a 14-month severance package, which is a 14-month notice period. That's what the offer would be. If you are wanting to increase the working notice part of it, it may be possible. These things are always negotiable. It's something that parties negotiate. It's what we help people do all the time. It's negotiable between an employer and an employee. It's a question of what is the employer prepared to provide and what is the employee prepared to accept, all within a reasonable range of what severance should be for that specific individual. And so it depends on what your specific circumstances are, Joanne. I'd need to know your age, your length of service. We'd have to get more information from you to be able to tell you what range you might fall into. But assuming, if you would be owed more severance, it's all negotiable, and you may be able to negotiate a longer working notice period, or you may be able to negotiate a higher severance amount. So rather than 12 months, they may be prepared to offer you, I don't know what you would be owed, but let's say 14 months, 16 months, whatever the case may be, depending on what you would be owed. In most cases where employers offer a combination of working notice and severance pay in lieu of notice, there's usually a reason for that. So if they've given you 2 months of working notice, it may be because they're making changes in the workplace, and that's the amount of time that they would either require to transition your role, or maybe they're shutting down your physical workplace in 2 months, and so they've given you 2 months working notice until there's no facility anymore, and that's why they've converted into severance after that. So there's all different reasons, but there usually is a rationale from the employer of why they chose 2 months working notice and then 12 months of severance. And so if there is that kind of rationale that I'm talking about, it may be difficult to receive more than 2 months of working notice, because ultimately it's within the employer's discretion to offer that to you, however they'd like and how it works best for their operations. But if there isn't a reason, if let's say they've just chosen 2 months in an arbitrary manner, maybe they would be willing to extend that period. So it's certainly something worth exploring. I always say it's good to stay open-minded. Severance packages, can look like whatever the parties want them to look like. It's all negotiable. And so certainly it's something that we could look at. But for the most part, just looking at the information I have for your situation, Joanne, it's more likely that the employer, if they're going to negotiate and they are going to be prepared to improve what they've offered you, it's more likely that they would offer you more severance rather than more working notice. Just in my experience, that doesn't mean it's not possible. It just means it's not super likely. But certainly you can get in touch with us. We can go over the situation with you and let you know where you stand, let you know if you are owed more, and how we can go about pursuing that for you. Okay, I have a question from David on Facebook who says, I'm currently on EI sick leave. My employer has requested more medical information to deal with accommodations. Are they allowed to ask for all medical info or just specifics? So if you're on medical leave, your employer does have a right to certain information. They're not entitled to your whole medical file or your medical records, for example. So you certainly don't need to provide them with kind of a blanket consent to all of your medical records or all of your files. But they do have the right to certain information, like, for example, a diagnosis, prognosis to a certain extent in terms of when do we think that you might be able to return to work? Is there maybe a return to work date that your doctor has in mind? Or is this something where you're going to have to be assessed on a month by month or even longer basis? So that kind of information should be made available to your employer just so that they can plan accordingly while you're on medical leave. And make sure that everything runs smoothly. They are allowed to put a replacement in place for your position while you're on medical leave, but only temporarily. Once you're approved by your doctor to return to work, you'd have to go back to the same position, same terms and conditions that you had prior to your leave. Again, as long as your position exists. So if, let's say, you're on leave for a while, there's a restructuring and your position is eliminated, then of course the employer can't put you back to the same role, but they would have an obligation to provide you with comparable employment. And if, let's say, that comparable employment doesn't exist, then it would be a situation where you'd be owed a severance package. And so with respect to what they're asking for, no, not all medical information would have to be provided, but some, definitely some within reason would have to be provided. And usually it would be at the time that you go off on leave that you would provide some of that information. And then as your leave goes on, the employer may check in for an update. If you've been on leave for a while, they may check in to see how you're doing and ask for an update in terms of when you might be able to return to work. And then, of course, when you are able to return to work, that's when you would again be providing medical information to your employer. And you'd have to provide usually a letter from your doctor clearing you to return. So your doctor would have to essentially sign off on your return to say, you're no longer prevented from working because of your medical condition. And in most cases, there would be some sort of gradual return to work, or maybe you would have a need for accommodation. And so any restrictions that you would have because of your medical conditions when you return to work, any accommodation needs that you would have should be outlined in a letter from your doctor that you would provide to your employer prior to your return to work so that they can accommodate you when you return. And in most cases, the employer will have an obligation to accommodate you. Most accommodations are feasible. The only exception to that is that employers would only have to accommodate to the point of what's called undue hardship. So if, let's say, it's not possible for them to accommodate you, and I mean really not possible, not feasible, or it would cost them a significant amount of money, those are situations where they may not have to accommodate you. But short of those types of situations, they would have to accommodate you, even if it's a pain for them, even if it's inconvenient. That doesn't mean that they can't do it. And the law does recognize that when employers are accommodating employees, of course, there's going to be a certain level of inconvenience, but that's to be expected and that's okay. When we're looking at what constitutes undue hardship, it's really beyond inconvenience. And like I said, it would have to be, almost impossible, or it would cost them, a really, really exceptionally significant amount of money. So I hope that answers your question, David. If you do have more questions about this, feel free to contact us. You can go to our website at employmentlawyer.ca, and all our contact information is there if you do need more assistance kind of navigating the situation. And we'd be happy to help you however we can. All right, so this brings us to the end of our session for today. Thank you very much, everyone, for joining. Thank you very much for your questions. If you have more questions, we have other sessions next week, so feel free to join in then and send in your questions. And I hope that everyone has a wonderful weekend.